Hello, everyone. I want to thank you all for being here. I'm excited to be here with you today, and I look forward to actually meeting you in person, or at least over Zoom, at the end of this presentation to answer any questions you might have. My name is Jerry Carbo. I'm a professor at Shippensburg University. I am also the president of the National Workplace Bullying Coalition and an attorney in West Virginia. I've been studying or working in or looking to eliminate workplace harassment and workplace bullying for nearly 25 years as a researcher, as a former HR manager, employee relations manager, as a plaintiff's attorney, as well as a consultant. And today what I'm going to talk about really is a lot of the basis of my research, the basis of my sort of path to solving workplace bullying. And I'm going to talk about legislating against workplace bullying. I'm going to discuss the current US laws for two reasons. One, so that you're aware of the few remedies that are available, even though those remedies definitely fall short of what we need to address workplace bullying. And then also to identify those gaps in those laws, and then to discuss how the Dignity at Work Act can close those gaps. And finally, what you can do to help us to pass legislation, as well as taking other steps to address workplace bullying. So, if I can get the slideshow working. There we go. So, first of all, whenever we talk about anti-bullying legislation, there are a number of things that the legislation really needs to do in order to be effective. One of the things is that it really needs to assure a positive right to dignity and respect in the workplace, rather than approaching things from a negative right standpoint, which is sort of the typical approach of the US legal system. So to really fully address workplace bullying, we need to have sort of a paradigm shift from positive rights to negative rights. Any legislation to be effective also has to provide a complete remedy for all targets of workplace bullying and harassment. In other words, we really need to look at remedies that will make targets whole. And we have to make sure that we provide access to those remedies. Plaintiffs today, even under the few protections that they do have in the United States, oftentimes have difficulty finding attorneys to represent them because of the costs of litigation versus the potential outcomes of litigation. And so we need something that provides an access to remedy. And finally, in order for a law to be effective, it really needs to provide a strong incentive to employers to prevent, detect, remedy, and eliminate workplace bullying. You'll hear that phrase a lot from the National Workplace Bullying Coalition. It's really our mantra: to prevent, detect, remedy, and eliminate workplace bullying. And one of the things that we know is that we need strong laws with strong enforcement to do so, but we also need employers doing the right thing, because even with the strongest laws, there's no way to enforce every single workplace in the United States. When we look at current US laws, we see there is a big gap in coverage. And we'll look at a number of these laws, and I'm actually presenting them here on this slide in reverse order of how we'll cover them. But we'll look at the EEO and state human rights laws and how those address workplace harassment, a very similar phenomena to workplace bullying, or a subset really of workplace bullying. Common law approaches, really the one tort or common law avenue, intentional infliction of emotional distress. Spend a short time on that because it's really not much of a remedy at all. Same for workers' compensation, unemployment compensation, and potentially Occupational Safety and Health Act, and whether or not it could address or does address workplace bullying. First, looking at unemployment compensation, a couple of things that we see right away why this has gaps in it and why it's not an effective remedy. First of all, it only covers targets who've been unemployed. And ideally, what we want to see is that nobody should have to leave their job in order to be compensated. Nobody should have to leave their job in order to get away from workplace bullying. In the ultra-competitive labor market that we see over the past 15 to 20 years in the United States, it's really unfair to simply say to targets, hey, go and find another job, because life is not really that easy. And finding an equivalent job is not that easy. And people put a lot of energy, sweat, effort into their work, into getting their work, into developing themselves in the workplace. So that shouldn't be the option. The other thing with unemployment compensation is it's limited compensation. It's not a full remedy. It doesn't cover, things like pain and suffering and compensatory or punitive damages. And as a result of that limited compensation, there's also really no employer incentive to address workplace bullying if unemployment compensation is the only way to recover it. And again, it only covers discharge. So we're really talking about employees who've been fired. While most states allow for constructive discharge to be argued in unemployment compensation hearings, there's no guarantee that somebody who leaves, who's forced out due to workplace bullying, is going to be able to even collect unemployment compensation. When we look at workers' compensation, we have a lot of the same issues. The remedy, again, it's limited. It's usually 2/3 of lost pay. Again, only we would cover targets who've lost work or they're out of work, which we want to avoid, or have medical expenses. And we really want to cover workplace bullying. We want to put an end to it if it occurs, because ideally we want to prevent, but we want to put an end to it before there are actual medical expenses. Most bullying also falls under what we call psychological to psychological harm. It means that a psychological act, such as intimidating or yelling at or harassing, or most instances of bullying, a psychological behavior that leads to a psychological harm. And in many states, that is simply not covered under the workers' comp statutes. And the other thing that we see is just in reality, there are very few successful claims for workplace bullying under workers' compensation laws today. The current vice president of the National Workplace Bullying Coalition and one of the founders of the National Workplace Bullying Coalition, as a workers' compensation judge, was able to find a couple of cases or ruled in a couple of cases that workplace bullying did indeed lead to compensable workplace injuries. But those cases are the exception, not the rule. And as a result of that, once again, no real incentive for employers to prevent, detect, remedy, and eliminate workplace bullying. Occupational Safety and Health Act, while this has been used in other countries and jurisdictions such as Alberta and Canada, as well as parts of Australia to address workplace bullying, the US system is quite a bit different and quite a ways off from being effective in addressing workplace bullying through OSHA. There's no current standard under OSHA laws in the United States to guard against workplace bullying. Our OSHA Act in the United States, as well as state OSHA laws, really focus on physical hazards in the workplace rather than hazards like workplace bullying. And what we see today is, even if this were a strong law, which it's not in terms of workplace bullying, we need strong enforcement as well. And that just doesn't exist under our OSHA laws. In fact, due to funding, OSHA struggles to enforce their current standards and to enforce physical hazards and to address physical hazards in the workplace. So really not an effective avenue for addressing workplace bullying. Then we see the common law. So does common law give us any route? And the closest thing that we have under common law is what's known as intentional infliction of emotional distress. And this intentional infliction of emotional distress has a number of elements in order to have a cognizable claim or in order to be successful as a plaintiff that are really almost impossible hurdles. The first one is you have to show not only intent on the actor, but you have to show intent to cause severe harm. So really this malicious intent. And that's a really hard standard to meet. Their conduct of the bad actor has to be conduct that, as many courts have put, shocks the conscience, right? We're talking about this extreme behavior. And one of the things that we know is many of the behaviors of workplace bullying are pretty common in the workplace, so they don't really shock the conscience. And we also know that many of the acts of workplace bullying are employment practices that are used to bully targets. And so those would fall outside of these types of claims as well. And then the plaintiff, the target, would also have to show that they indeed suffered severe harm or severe emotional distress. Rarely, if ever, are these claims successful. And even if they are successful, the harm is already severe and not something any worker should have to endure. So not a really good avenue to address workplace bullying. So really what we have in the US jurisprudence, in the US legal system, is the closest form that we have to, or the closest route that we have to addressing workplace bullying today, is addressing unlawful harassment under the EEO laws and state human rights laws. But even here we have a number of gaps. So under EEO and state human rights laws, under the federal laws, we have Title VII of the Civil Rights Act, the amendment to Title VII of the Civil Rights Act, the Pregnancy Discrimination Act, one of the amendments, I should say, the Age Discrimination and Employment Act, and the Americans with Disabilities Act. Under these laws, it's unlawful to discriminate based on a protected status in any employment term, any employment decision, any employment condition. And as of 1986, 30 plus years ago, harassment was found by the Supreme Court of the United States to be one of the forms of discrimination that is unlawful under these EEO laws. And in that case, it was Meritor Savings Bank v. Vincent, and that dealt with a gender-based harassment claim. In order to be protected under these laws, a plaintiff has to show that the behavior is based on a protected status. This unwanted behavior, this objectionable behavior has to be based on a protected status. And under the federal EEO laws, these protected statuses are race, color, national origin, gender, which includes sexual orientation and identity, religion, age status over 40, and disability. State laws sometimes expand these protected statuses to things like familial status, political position, and expansion of age. However, that's it. If the bullying, if the harassment is based on anything other than these things, then it's not unlawful. It is not protected in the United States. So right away, we see a huge gap. When we talk about protected statuses, just to expand upon those a little bit, race includes things like race-linked traits, color includes skin tone, national origin also includes heritage and cultural practices and behaviors, religion includes religion or absence of religion, wearing of religious attire is also included, gender. And one of the things I want to stress about gender-based harassment is we oftentimes, even when we talk about unlawful harassment in the United States, we think of sexual harassment, which brings up this idea of sexualized or harassment that's sexual in nature. A better term that I prefer to see used is gender harassment, because while there are many instances of sexualized harassment that still occur today, the majority of gender-based harassment is not sexual in nature at all. And even that is sexual in nature tends to be more about control than any type of misguided sexual attraction or attempts to engage in sexual behavior. So when we talk about gender harassment, this includes pregnancy discrimination, it includes harassment based on sexual orientation and sexual identity, as I mentioned earlier. Disability harassment includes harassment based on perceived disabilities, including harassing an individual for asking for an accommodation, a very, very common practice and something that we have seen that has been very common during the pandemic. Includes harassment based on how one walks or how one talks. We also know that we intersectional harassment, a combination of two or more, for instance, harassing individuals because they are Black females or Asian males. That would be both harassment based upon race or national origin and gender. That is an intersection of two different classes, and that is protected under the EEO laws. That is unlawful under the EEO laws. And perceptions of being in a protected class are also unlawful. One of the things that we saw after 9/11 was that in the workplace, in addition to the myriad and the incredible number of attacks against Muslims in the workplace, Sikhs who are not Muslim were also attacked because they were perceived as being Muslim, and that's also unlawful. And again, some states expand these protected statuses. However, one of the things that we know is that when we're dealing with workplace bullying, about 4 out of 5 instances of workplace bullying are not based upon these protected statuses. And therefore, right at the very start of these EEO laws, we know that 80% of instances of bullying are not covered. And then we look at how the courts have defined workplace harassment, unlawful harassment in the United States. It's defined as unwelcome, offensive conduct that is based on, as we've already discussed, race, color, sex, religion, national origin, disability, and/or age, or any other protected status. Harassment becomes unlawful when enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a working environment that a reasonable person would consider intimidating, hostile, or abusive. And you see I have a star next to the severe or, specifically the or. One of the things that we have seen is that circuit courts, despite Supreme Court language to the contrary. Several of them have adopted a severe and pervasive rather than a severe or pervasive standard, creating more gaps in the law. When we look at the enforcement agency for these laws, at the federal level, it's the Equal Employment Opportunity Commission, and the EEOC generally has really strong enforcement guidance. When we look at the enforcement guidance in the forklift case, really the second Supreme Court case to deal with gender-based harassment, we see that there's very strong guidance that says, look, there doesn't have to be an economic injury, there doesn't have to be psychological harm, especially not psychological harm that requires treatment in order for these claims to be actionable. The hostile environment itself is actionable. The guidance here, from the earliest days of EEOC guidance, was clear that we don't have to show intent. We're really worried about the behavior in the workplace and whether or not a hostile environment was created. But that's not how courts have interpreted this. We see enforcement guidance for employer liability after the Farragher case and the Ellerith case in 1999, that this enforcement guidance laid out some pretty specific guidelines about what employers need to do in order to prevent, detect, and remedy workplace harassment, and the steps that the EEOC would expect employers to take in order for them not to be liable for the damage from harassment in the workplace. We saw that again with the EEOC Select Task Force report that came out in 2016 on the 30th anniversary of the Meritor Savings Bank case. And we're going to see it again, hopefully here soon, with proposed enforcement guidance. It also came out in 2016, but was put on the back burner for the past 4 years under the prior EEOC chair. And the current EEOC chair, Charlotte Burrows, has said that enforcement guidance is going to be resurrected, which is great news for those who targets of workplace harassment. We also see, so what are the gaps that we see? First of all, this protected status requirement creates a gap. The unwanted definition and how that plays out in courts creates a gap. The severe and pervasive standard creates a gap. The employer's defense creates a gap. And then even the harm, because while we see that the harm doesn't have to be psychological or physical, the idea of harm to the job simply doesn't always occur in bullying situations. In fact, targets oftentimes persevere and are very effective in their jobs despite the harassment and bullying. So protected status. One of the things we see is this protected status, even though it's not meant to be, has become an intent standard. And when I say it's not meant to be, we can look at Scalia's language in the Onkale decision, where he wrote, the critical issue, Title VII's text indicates, is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. Nowhere in here does he say whether or not a harasser intentionally discriminated against an individual or intentionally created disadvantageous terms or conditions of employment. And this has always been the standard. However, what we see is the circuit courts, in fact, the majority of circuit courts have put an intent standard here that says that there has to be this intent to engage in the behavior because of the protected status. That's problematic. It's tough to prove intent. It's tough to prove general intent. It's very tough to prove specific intent. Even if we didn't have this intent standard, though, what we know is 4 out of 5 incidents of workplace harassment are not based upon or targeted towards or affecting an individual simply based on their protected status. So already we start with 80% of claims not protected, and then we get this circuit court language that makes it even tougher with this intent standard. So what do we see? Even where we think that based on might seem obvious, it's not always the case for circuit courts. In Salgado v. Abbott Labs, the court decided that gender-neutral statements are not even relevant to showing sexual harassment. So if the statement itself is gender-neutral, even if it's directed only at female workers, the court there would say, we're not considering it. We're not looking at that. We're not allowing that to be admitted as evidence of the harassment. If the action is not sexual in nature, not part of the calculation. Again, we see this in the Pedroza v. Cintas case, the 8th Circuit in 2005. McCallum, same circuit, 8th Circuit, said that the behavior, not only must it be directed at a gender based upon their gender in order to be sexual harassment, but it must be based on sexual attraction. And we know that's really not what harassment's about, even when it is sexualized. In the 10th Circuit Court in 2004, the Risk v. King Soopers case, there the court said that sending of odd gifts and letters with statements that said, "I love seeing you in those jeans. Being a supervisor is hard, but I hope I look as good as you when I do it," was determined not to be clearly based on gender, and therefore the claim was thrown out on appeal. Going even further, in Holman v. Indiana, the court there said a married couple employed by the state alleged that their supervisor sexually harassed each of them with physical touching and sexual propositions. Here we're really talking about not just harassment, we're talking about assault. And the court said, we've got to dismiss these claims at the pleading stage, before a jury even gets to hear it, before the plaintiff even gets their day in court, because Title VII does not cover the equal opportunity or bisexual harasser. Then, because such a person is not discriminating on the basis of sex, he is not treating one sex better or worse than the other, he's treating both sexes the same, albeit badly. Here, the court has a legitimate, claim based upon Scalia's language in Oncale and based upon the 30 years of jurisprudence of harassment cases through the Supreme Court as well as the circuit courts. But at the same time, we see the lunacy of this type of decision, and we see why these EEO laws simply are not an effective path to addressing workplace bullying or generalized harassment, psychological harassment, or moral harassment. We also see problems with this idea of unwanted. In order for the behavior to be harassment, it has to be unwanted, and that seems okay, but the problem is how that's interpreted. And what we see is that from the EEOC standpoint, if someone files a complaint, that indicates that it's unwanted behavior. However, some courts have not adopted that standard. They have found where people laughed off conduct or have engaged in similar conduct in the past, that this indicates that the behaviors are not unwanted and therefore not unlawful harassment. When we look at the severe or pervasive standard, even if we don't look at the severe and pervasive standard that many circuit courts have adopted, we see that there are problems. When we look at the Farragher v. Boca Raton standard, it's not too bad. This is from the Supreme Court. Title VII does not prohibit genuine but innocuous differences in the way men and women routinely interact with members of the same sex and of the opposite sex. Simple teasing, offhand comments, isolated incidents, unless extremely serious, will not amount to discriminatory changes in the terms and conditions of employment. Okay, so, right, we're not going to cover, offhand teasing, sort of general differences in treatment, sort of the norms that we would expect to see in any interactions. The standards for judging hostility are sufficiently demanding to ensure that Title VII does not become a general civility code. All right, fine. We're not going to have a civility code in the workplace. I'm not sure there's a great reason not to have civility in the workplace. I think we should have civility, but the court said we're not going to have a civility code. Properly applied, they will filter out complaints attacking the ordinary tribulations of the workplace, such as the sporadic use of abusive language, gender-related jokes, and occasional teasing. Now, when we look at all this language and we say, okay, these aren't really attacks, these aren't things that will create a difference in an environment, these are things that are sort of passing in nature, they're not degrading in nature necessarily. All right, we have an okay standard. But again, that's not how so many of the circuit courts, which are critical, the first appellate level, and it's also not how the district courts then apply this standard in practice. First, a number of courts have said it has to be severe and pervasive. So even the most severe behavior, if it's only occurring once, these courts would say not enough. Just to give you an example of this, there's a district court case where a supervisor pinned a secretary up against his door, groped her, sexual assault, should have been arrested for it. The court said one-time offense, not enough to be harassment. Other courts have gone beyond the severe and pervasive standard, and they've extended well beyond what we would call a civility code. One of these cases is Baskerville v. Colligan International. And there, a very respected judge, Judge Posner, a judge who during his career was considered for the Supreme Court, was on the short list a number of times, found that only a woman of Victorian delicacy, a woman mysteriously aloof from contemporary American pop culture in all its sex-saturated vulgarity, would find a gesture intended to simulate masturbation, grunting sounds as she walked by her alleged harasser, and a statement that one public address announcement really meant that all pretty girls run around naked, any more distressing than the heat and cigarette smoke of which the plaintiff did not complain. All kinds of problems with this decision. One, these behaviors that he describes here have no place in the workplace. Clearly, these behaviors create a hostile working environment. Clearly, these behaviors are based upon gender. Clearly, these behaviors should be found to be unlawful. But then the second statement seems to intimate that if an individual is not offended by heat and cigarette smoke in the workplace, then they can't be offended by unlawful, sexualized even, gender-based harassment, which is a ludicrous standard. And you would think that maybe this case would just be an anomaly. Unfortunately, what we know, this case in this very language and the language that follows it to set out what Posner defined as harassing behavior has been cited to dozens of times since that point in time, and is still cited to today by circuit courts. Hartzell was one of those courts that cited to it in the Fourth Circuit. And Hartzell, in that case, using the Baskerville standard, said that an environment in which supervisors had informed an employee that they had made every female in the office cry and would also make her cry. Right there is enough to create a hostile working condition, telling somebody, we're going to make you cry. Called a female sales assistant his slave, pointed out a bosom catalog model and asked why they did not have sales assistants like that, referred to the plaintiff's husband as a stay-at-home wife, and asked the plaintiff, why don't you go home and fetch your husband's slippers like a good little wife? That's exactly what my wife is doing for me. Was not severe and pervasive enough to create an actionably hostile working environment. So these are, incredible standards, and they are followed by dozens of cases. The job effect can also create barriers. Sometimes it's tough to see that there has been unreasonable interference with the working environment. Many targets persevere and actually are sometimes the best performers in their job. We actually encourage coping training and mechanisms, and these can hide the job effect that many courts have decided we need to see that in order for this to be actionable harassment. And then we get to the defense. So in what the Farragher case really set out, what the Supreme Court really set out, is a two-pronged defense for employers where there is supervisory harassment that does not create a tangible adverse job effect. In Farragher, the court said there are three levels of liability. There's liability for coworker or third-party harassment if the employer knew or should have known of it and they didn't take prompt, immediate remedial measures. There is liability for supervisory harassment by a supervisor that leads to a tangible adverse job effect. Employers are held strictly liable for that, no defense. And then there is harassment that's by a supervisor that doesn't lead to a tangible adverse job effect. And this tends to be the largest category of harassment. And there the court said that in order to show the two-pronged defense, in order for employers not to be liable, they have to show that they exercise reasonable care to prevent and correct promptly any harassing behavior. Same as that third party or that coworker standard, right? They have to show that they've taken these steps. And second, they have to show that the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to avoid harm otherwise. Now, this doesn't seem like too bad of a standard, right? Employers, you've got to take some steps. There's the incentive, right? Employees, if those steps are available, you need to take those. If they're not available, you can look to avoid harm otherwise. And you should look to avoid harm otherwise. But the problem is that, first off, that avoid harm otherwise has been completely ignored by circuit courts. So what this standard has become is the employer system needs to be reasonable, and the employer has to show that the employee didn't follow it and that they were unreasonable in not following it. We talked about that already. In this first prong, little has been done to define what measures employers should take. Again, the EEOC guidance lays out a number of expectations, but circuit courts simply have ignored those. What should a reporting process look like? What should the investigations look like? What should the remedial processes look like? We know what's effective, but that's not what's required. A reasonableness standard has led to allowing employers to set the standard. And that's what we look at. What are normal employers doing? What are their normal policies and practices? And that's the standard that we hold all other employers to. There have been no requirements for employers to take the measures that have been recognized as effective internationally and in the research. Second prong has just been flat out eliminated by some courts when there's a single incident. So if there's a single incident, automatically that second prong, employers have met that second prong. All we have to worry about is, do they have an effective policy? And that effective policy is just based upon what other employers are doing. Courts have overlooked many of the reasons, and also in this second prong, as to why targets do not report. All of these are covered in the EEOC guidance, but many of those are ignored by the courts. First of all, failure in the past by the employer to investigate or manage other complaints. This is a legitimate reason why somebody wouldn't file a complaint. If they have no expectation that there's going to be any positive outcome, why would they file? And the research shows us that there's probably not going to be a positive outcome or any outcome to address the harassment. The likelihood of retaliation. We know that over 70% of cases where an individual files a complaint, even internally, they're going to face retaliation. So that's a good reason not to file complaints. Narrow reporting systems, where the target, who wants to report, which is a very tough step to take. It's a very courageous step to take. Oftentimes they have to report to someone they're not comfortable with, rather than having wide reporting avenues. The EEO laws also leave a lack of access to remedies. What happens is, once somebody files a complaint internally, if they then go externally, they file the complaint with the EEOC or the State Human Rights Commission. And with the EEOC at the federal level, if the EEOC does find cause, they then ask the parties to engage in a conciliation process that is entirely voluntary for the two parties. And this is just a mediation process. Can we reach an agreement? The EEOC can then litigate on behalf of the complainant if they so choose, but they have a limited budget in doing so. And really, they only take novel cases. So the majority of complainants aren't going to have the agency there to litigate for them. The most likely outcome is they're going to be given a right to sue letter. And in most states, it's hard to find an attorney to take an employment case on contingency. This is especially the case for low-paid workers, where the attorney is unlikely to get attorney's fees, even if they're successful, from the defendant, and the compensation is likely to be low. Fee-based attorneys, impossible for most employees in the United States to afford. $300 to $600 per hour, where a simple case can easily run into the $50,000 range or more for attorney's fees alone. That's hard for most targets to afford, and so they really don't have access to a remedy. So what gaps have the EEO laws led to? Well, the majority of incidents are not covered. Just at the very beginning, because they're not based upon a protected status. This continued pervasiveness has led to the continued pervasiveness of unlawful behaviors. We know that claims continue to increase, or at least to stay steady. There's no significant decline. And this is why in 2015, the EEOC put a task force together to look at, why are we not seeing a decline after 30 years in workplace harassment cases? The majority of cases are not reported, and justifiably so, because there's not a real great path to success, even if you are a target of harassment based upon a protected status. It's led to a great deal of retaliation, a lack of success for those who do come forward, and no real incentive for employers to adopt best practices to prevent, detect, eliminate, remedy workplace harassment. Again, extremely pervasive. 30,000 reports of harassment are filed with the EEOC each year. We know this is just the tip of the iceberg. Up to 85% of women have been targets of gender-based harassment. 40 to 60% of men have faced gender-based harassment. 58% of the LGBT community have been targets of workplace harassment. 40 to 60% of minorities have been targets of race-based harassment. 25% of individuals with disabilities have faced harassment based upon a disability. 25% of older workers have faced harassment based upon age. All those stats from the EEOC Select Task Force report. It's underreported. Only 30% of targets talk to a supervisor or HR. Only 6 to 13% actually file a formal report, and about 2 to 3% of claimants that file that initial claim ever get to any type of court award or order. Employer systems are ineffective. About 1 in 8 reports to HR lead to worse outcomes, and less than 1 in 3 lead to any improvement, and 1 in 2 lead to no change. The most likely outcome for the target who reports is to lose their job, either voluntarily or involuntarily. So moving on to the Dignity at Work Act, we know U.S. jurisprudence doesn't work. We know it has huge gaps. It has huge gaps for both general harassment as well as harassment based upon protected statuses. And the Dignity at Work Act is written to close those gaps. First of all, the Dignity at Work Act provides a positive right to dignity, a positive right for workers to be treated with respect, esteem, belongingness, growth, voice, and other human rights in the workplace. It makes all forms of bullying and harassment unlawful, eliminates this hurdle of intent, recognizes the broad array of harm, and provides for a full and complete remedy for all of that harm, in essence, assuring make whole remedies, provides access to all targets to that remedy, and provides a strong incentive for employers to take necessary steps to prevent, detect, remedy, and eliminate workplace bullying and harassment. To really adopt those policies, those practices that we know through research and years of jurisprudence that work to do this, that work to prevent, to detect, to remedy, and eliminate harassment and bullying in the workplace. Dignity at Work Act, we see the positive right. Section 2, the purpose statement. It is the purpose of this act to recognize and protect the right to dignity and other human rights in the workplace, and to prevent any abusive or negative behaviors that infringe upon these rights in the workplace. Further down in the Act, it assures a right to dignity, and it defines a right to dignity in the definition section. The fundamental right to receive respect for one's dignity as a human being, and the right to enjoy the conditions necessary for human dignity to flourish. Respect for dignity implies the right not to be treated in degrading or humiliating manner. And we see the broad definition of workplace bullying to include all forms. It's defined as the unwanted abuse of any source of power that has the effect or intent to intimidate, control, or otherwise strip a target of his or her right to esteem, growth, voice, or other human right in the workplace. Again, eliminating this requirement of showing intent, a hurdle that is almost impossible to overcome. Again, DAWA addresses all forms of bullying and harassment are unlawful. It's unlawful for any person to engage in workplace bullying, moral, psychological, or general harassment of a coworker under DAWA. Workplace bullying shall be defined again as the unwanted abuse of any source of power. As I just mentioned, a number of examples, a number of different terms are included here: moral, psychological, general harassment, incivility, abusive supervision, violence, mobbing, aggressions, and other types of objectionable behavior are all included within this definition. Again, DAWA eliminates a hurdle of intent. Intent is always difficult to prove. The Supreme Court of the United States recognized that proving intent in a discrimination case is unfair to plaintiffs when they established the McDonnell-Douglas shifting burden analysis for disparate treatment or intent-based cases of discrimination. And we need to do the same with harassment. General intent, the intent to act, is difficult, but specific intent or malice, the intent to act in a way to cause the resulting harm, is nearly impossible to prove. And again, DAWA adopts a measure of effect of or intent to, rather than requiring a showing of intent. DAWA recognizes the broad array of harm and provides a full and complete remedy for all those forms of harm. Under DAWA, an employer shall be liable for any damages, including economic, compensatory, and punitive damages to any employee who's been the target of any of the prohibited behaviors here. In addition to that, an employee is entitled to recover nominal damages, the greater of actual damages or nominal damages of $5,000 for each violation of this act. In addition, any employee who collects nominal damages, their attorney can also collect attorney's fees from the defense. DAWA recognizes the broad array of harm and provides a complete remedy. Again, when we look at the remedies section, economic damages, compensable damages, punitive damages are all available, as are injunctive relief and other equitable remedies, and any other remedy that the court or the adjudicating body finds appropriate, including medical expenses, restorative measures, training, and attorney's fees. DAWA provides access to a remedy. Under DAWA, workers have a number of options. First of all, they do have to file the initial complaint with a commission that we recommend be established to enforce the Dignity at Work Act. Once they file there, they also have the option to go through the same process as what we see with the EEOC, which is to get a right to sue letter and then to litigate. They have a 3-year statute of limitations, so we expand the statute of limitations to what we believe is a reasonable time frame rather than the 180 or 360 days under the current EEO laws. And we also provide the commission a number of powers to enforce this through fines and penalties, as well as powers to actually adjudicate cases, which will give complainants not only an access to that adjudication that they might not have, but also give them access to a speedy adjudication of their claim, which might allow them to remain on the job the way that we see in other jurisdictions where labor courts are used, such as labor courts that are used in Quebec and other provinces in Canada. DAWA also provides a strong incentive for employers to take the necessary steps to prevent, detect, remedy, and eliminate workplace harassment. I stress the necessary steps because that's a language that's used in international laws, saying, not just the reasonable steps, but we know what's needed to eliminate these behaviors. We know what's needed to prevent these behaviors, to detect them, to remedy, and then to eliminate them. And so that's what we expect employers to take. Employers under DAWA will have a general duty to ensure that to take all necessary steps to prevent, detect, remedy, and eliminate workplace harassment and bullying. At a minimum, they shall put in place systems to monitor, prevent, and manage workplace bullying, ensure workers are adequately informed and trained on bullying. We also provide, in essence, a model policy that these are the things that employers should do. At a minimum, post notice, establish a general harassment policy, have a broad reporting procedure, have formal and informal reporting methods, affirmative steps taken to detect harassment that isn't reported, such as workplace audits and climate surveys, an effective investigation process that is neutral, that is done by experienced and well-trained investigators, an effective remedial process that assures that the current bullying ends and deters other future bullying, and a process that assures that retaliation is prevented. So what can you do to help eliminate workplace bullying? What can you do to, if you believe in the potential of the Dignity at Work Act, what can you do to help us pass DAWA? You can sign up with the National Workplace Bullying Coalition today, or Dignity Together. You can go to either of those web pages or Facebook pages, or to the Dignity at Work Act website to join a state team that will push for passage of DAWA and related legislation. You can also lobby your elected officials to take on this problem, to take on this really epidemic of workplace bullying and harassment. Demand your union stand up and take steps. You can help to bring attention to workplace bullying and the harm it causes to targets, witnesses, families, communities, organizations, and society. Get the word out there to your friends, your family, your colleagues, so they understand the importance of this problem. It really will take a movement for us to effectively address workplace bullying. And here's the dignityatworkact.org website that you can go to, and you'll see that on this website, there's a link for taking action. And when you click on that link, this is what the page will look like. And here you can email, you'll get information about steps that you can take, and you'll become a member of our organization, either formally or informally, as a supporter and somebody who wants to address workplace bullying. So I know it's a lot, and I know it was a long presentation. I want to thank you for your patience, and I hope that if you have any questions, that I can answer those for you at this point in time. Thank you.